Good morning. Call to order the 10th meeting of the Rhode Island Ethics Commission scheduled for July 1, 2025. First item on the agenda is a motion to approve the minutes of the open session held on June 10, 2025. Is there a motion? Motion by Commissioner Callahan, seconded by Commissioner Susie. A roll call vote. Commissioner Susie.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Celerini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Next item on the agenda is the director's report.
Good morning. Let's see, let's start with complaints and investigations. We have 5 complaints pending as of today, including a newer one that I'll get to in a moment. Just to go down the status of each of these, in the James Thorson complaint, Juneau discovery has been ongoing. Deposition was scheduled for a couple of weeks ago in Philadelphia on June 20th. Prepared to go to Philadelphia to participate in that. Really, at just the last moment, the witnesses got an attorney who needed time to prepare, and so it was postponed. So there's not another date scheduled yet, but I expect that that'll happen over the summer. I'll let you know about that. In the
Before you move on, there were 2 witnesses I recall in Pennsylvania. Are they both under subpoena?
yes, they're both from the same group. They work together, both subpoenaed. They did provide documents as part of that subpoena, and those documents have been shared with us also. So that part of the subpoena has been returned. Any other questions about that particular case? In the Heidi Weston Rogers complaint, that's 2024-12. You know, I've reported to you that investigation is completed, and counsel are working on dates now. So what we're looking at for an adjudication in that case is an adjudication date probably in October, conceivably November in that case. Let's see. In Jason Licciardi Sr., that is the investigation is finishing up, and it looks like we're going to have a probable cause hearing at the very next commission meeting. So expect that to be an executive session, a probable cause hearing in that case. And then we have one new complaint that you'll hear about today in executive session, where we'll have an initial determination. It'll be your first look at that complaint. And that is against Robert Lombardo. That's it on complaints for now. Advisory opinions, we have 7 pending as of today, 4 on today's agenda. And so right now we have 3 outstanding. Probably have 7 again by now. So they keep coming in, which is great. We want them to come in. I mean, that's a sign of a commission, ethics commission, that's getting the word out that you should be asking for advice beforehand, not after the fact. So that's good. APRA requests slowing down a little bit in the summer. We had 5 since the last meeting. We completed 4 of those within 1 business day. One of them, it took 2 business days, but that's only because the person who sent the email request in sent it to one of our investigators who was on vacation. So when he came back the next day, we processed it. The 4 of those related to advisory opinions, and one of them was a request for the meeting video. They could have gotten online, but we gave it to them if they wanted. Just briefly then on financial disclosure, just to cut to the good news is there are 8 non-filers left for the entire 2024 filing year. 7 of those are municipal officials, no electeds, and 1 is a charter school board member. So that makes our compliance rate as of this morning 99.81%. Pretty great. And I know I said I wish you could all see the work that our investigators do to track these folks down, and the telephone calls and the most respectful phone calls, you know, really And even at the end, I want to say that, you know, even as we get down to these last few, the reason you want to be so polite and respectful is, you know, we're going to find out that one of these 8 is really having, you know, something is wrong, right? And so they're in the hospital, there's an issue, not all of them, but history tells us that one of them will be, and someone like that, we'll do what we need to do to get them to file. If they need a little extra time, we'll give them a little extra time. Some assistance. Nevertheless, complaints are forthcoming, so we'll have some news on it. And finally, just generally, the next meeting is July 29th. I anticipate that we will have that meeting. And that's about all I have for directors. Happy to talk about anything you want to talk about or answer any questions.
Commissioners have any questions for the director? So the signage should. The next item on the agenda are the advisory opinions. The first person on the sign-up sheet is Robert Runge.
Good morning.
Good morning.
Good morning, Commissioners. This draft advisory opinion is in the top B in your binders. Mr. Runge is employed as the grants administrator and on-house coordinator for the City of Pawtucket Department of Planning and Development. He's on guidance today regarding whether he's prohibited by the Code of Ethics from accepting an appointment to the Board of Directors of Blackstone Valley Advocacy Center, which is a private domestic violence center, given that the center seeks and receives grants from the City of Pawtucket. As grants administrator, the petitioner oversees various grant programs, with the exception of 3 specific types of grants: the Community Development Block Grant, the Home Housing Funds, and the Emergency Solutions Grants. Those 3 funds are overseen by the Community Development Block Grants Manager, who is a colleague of Mr. Runge. The petitioner represents that the center applies for and receives one of those 3 grants. And the petitioner further represents that although the emergency solution grants are administered by the department by which he is employed, he does not have anything to do with establishment of the requirements or the criteria for those grant applications. He did not receive those grant applications. He doesn't review them, and he does not award the grants to the successful applicants. He explains that the criteria for the grant applications is established by the United States Department of Housing and Urban Development. The applications are received by his colleague, who reviews them for compliance, compiles them, and sends them out to the mayor. The mayor reviews those applications, selects the successful candidates, and then awards certain amount to each successful applicant. Mr. Runge represents that he does not oversee the Community Development Block Grant Manager or vice versa, and their positions are lateral to each other. I have listed the pertinent provisions of the Code of Ethics on pages 2 and 3 of the draft. Here, none of those provisions of the code prohibit the petitioner's simultaneous service as an employee or as a grants administrator, an in-house coordinator, and as a member of the board of directors of the center. Additionally, based on the facts as represented, there is no indication that serving as a member of the board of directors of the center would impair his independence of judgment in his public capacity. However, such simultaneous service requires him to remain vigilant and identify any potential conflict of interest that may arise, given that as a board member of the center, he would become a business associate of the center. The code would require him to recuse from discussions and decision-making on any matters that may impact financially the center, also from any matter in which any representative of the center appears to represent the interests of the center. He would also be prohibited from representing the center before his department. And he would be prohibited from sharing any confidential information that he has acquired during his public duties with the center. Thank you. I'm happy to answer any questions you may have of this.
Morning, Mr. Rungy. You've heard the presentation, read the draft advisory. If you have any questions, concerns, or comments?
I do not.
Members of the commission, anyone have any questions, concerns, comments? Hearing none, is there a motion to approve and issue the advisory opinion as presented by the staff? Moved by Commissioner Ritchie, seconded by Commissioner Rapidu. Roll call vote, Commissioner Susie.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rapidu.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Thank you, Mr. Rungy.
Thank you.
Next item is Thomas Cronin.
This is in the top eight.
Good morning.
Now, the petitioner was recently nominated for appointment by the Coventry Town Council, the position of municipal court judge. In his private capacity, the petitioner is an attorney in private practice, and his law office is located in the town of Coventry. His practice focuses on land use matters, and he represents clients before the Coventry Town Council, the Coventry Planning Board, and Zoning Board. He also represents that his law partner focuses her practice on estate planning matters, and she ordinarily represents clients before the Coventry Probate Court. The petitioner is here today to seek guidance from the Ethics Commission regarding whether upon his appointment to the position of the Coventry Municipal Court Judge, he would be prohibited by the Code of Ethics from representing clients before the Coventry Town Council, Zoning Board, Planning Board, and the Probate Court. The petitioner states that the municipal court has jurisdiction over traffic violations, housing violations, animal control violations, and various other violations of town ordinances. Given his practice, and he would not ordinarily represent clients before the municipal court. Attorney Cronin represents that the town has only one municipal court judge. In circumstances where the municipal court judge is unavailable or has a conflict, then the probate judge presides over municipal court matters. However, vice versa is not true. Members of the Coventry's planning and zoning boards, as well as the probate judge, are appointed by town council. The municipal court does not have any appointing, fiscal, or jurisdictional authority over the town council, the zoning board, the planning board, or the probate court. The municipal court does not have appellate jurisdiction over matters heard by the town council, again, all those for public bodies. I also have cited several provisions of the Code of Ethics that I have taken into consideration while drafting this advisory opinion. They are on pages 2 and 3 of the draft. The Ethics Commission has consistently opined that the Code of Ethics does not prohibit municipal judges, including municipal court judges, from representing clients before other municipal bodies over which the municipal judges do not have jurisdiction in their judicial roles. I have listed several advisory opinions on page 3 of the draft. Here, although the town council is the appointing authority of the municipal court judge, the municipal court judge is not a member of the town council and is not an employee of the town council. The municipal court judge is likewise not a member of any of the other public bodies, the planning board, the zoning board, or the probate court. The petitioner does not have appointing authority over the members of those public bodies, so have fiscal jurisdictional or appellate jurisdiction over those municipal bodies as well. The petitioner representation of clients before the aforementioned public bodies would be on matters unrelated to any in which the petitioner is involved as a municipal court judge or over which the municipal court has jurisdiction. Accordingly, based on the petitioner's representations, prior advisory opinions issued, and the review of the code of ethics, it is the opinion of the staff that the code would not prohibit him upon appointment as a municipal court judge from representing clients before the town council, zoning board, planning board, or the probate court as needed. Thank you. I'm happy to answer any questions you may have at this time.
Mr. Cronin, you've heard Ms. Papa's presentation. You've previously seen the advisory opinion, draft advisory opinion. Do you have any questions, concerns, or comments?
No, it's quite well said.
Members of the commission have questions, concerns, or comments?
I have a question, Mr. Chairman, perhaps you can help me with the direction, but in just using this particular case as an example, Mr. Cronin's case, is there a mechanism for, as an example, if a member of the town council or a member of the zoning board or the member of a planning board were to be before Mr. Cronin in a role, in a legal matter, where there's a potential for a power differential? That's the term I would use from my ethics training in the military. Is there a recusal process? So I apologize, but it's sort of the reverse.
So normally under the code, a public official may not represent himself before his own board or before a board over which he has
Yeah.
appointed authority.
Yeah.
Unless there is a hardship exception.
Yeah.
So the town council member would more likely have to request an advisory opinion to appear before Mr. Cronin. And my understanding is that in those circumstances, Mr. Cronin would recuse and then the probate court judge will step in.
If,
Although,
maybe a different example, if a member of the town council had a speeding ticket.
That's what I mean,
Right, and it would,
a legal matter.
had a speeding ticket go to municipal court, I would imagine that the judge would recuse himself and the alternative would be available to sit on that matter.
I believe, Mr. Senarini, that, the Coventry Police Department, as a prosecutor, has the authority, to send that matter to the traffic tribunal.
Okay,
And that's the more likely scenario.
all right, sir, thank you.
That would be to avoid the conflict.
Yes, avoid completely. Each time they issue a ticket for a moving violation, in your example, they have the discretion to send it either to the traffic tribunal or to the municipal court.
And so are you suggesting that any sort of other legal matter that might be in the same, same concept would be handled the same way? Is that how you would manage it?
Yeah, most of the infractions, let's call them, because they don't
Yeah,
rise
good
to the
word.
level of
Thanks. Yeah,
something
no,
else.
good word.
We have concurrent jurisdiction with either the district court, the traffic tribunal. The municipal court is almost completely discretionary as to who brings the charge. So, in all those cases, I think it could be referred to the court, the other court available.
Super helpful. Thank you very much.
Anyone else? Well, I want to express a concern I have. And it has to do with appearing before the appointing authority. And I want to express it from the perspective of an attorney. If I go with my client, Mr. Cronin shows up with his client, we're both before city council that's already appointed him to his position. But I'm gonna feel like I'm in a home, a visiting arena, not a neutral arena, because they've already appointed him. They already like him. So I have some concern. Doesn't change my opinion on this particular opinion. But I'm expressing to my fellow members, commissioners, that I have some concern about that. Because I have no problem, zoning board, planning board, those things. They didn't appoint you, but I do have concerns about hearing before you're appointing authority.
I share those concerns.
I thought you might. With that said, is there a motion to approve and issue the advisory opinions presented by the staff? So moved. Commissioner Callahan, motion, Commissioner Alvarez, seconded.
Michael.
I'm sorry, Commissioner Brown, I'm sorry, I can't tell whose voice it was coming that way. Roll call vote, Commissioner Susie.
Aye.
Commissioner Browner. Aye. Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. Aye. And the chair votes aye. Thank you, Mr. Cronin.
Thank you.
Appreciate it. Good work.
Thank you.
Next item is Priscilla Glucksman.
Good morning, everyone. The draft for this particular is at tab D in your binders. Welcome, Attorney Glucksman. The petitioner is employed as the administrator of the Office of Child Support Services, a division of the Rhode Island Department of Human Services. In that role, she assists the associate director with implementing the mission of that agency, which is to enhance the well-being of children by assuring that assistance in obtaining financial and medical support is available through locating parents, establishing paternity, establishing support obligations, and monitoring and enforcing those obligations in the family court. The petitioner identifies the chain of command at the Office of Child Support Services in descending order as follows. The associate director, then there's the administrator, who is our petitioner. There are 2 assistant administrators, 3 senior casework supervisors, and a total of 39 child support enforcement agents. And they are divided into categories 1, 2, and 3, with 3 being the most experienced. The petitioner's daughter is a new college graduate who recently applied to become a Category 1 child support enforcement agent in response to a posting that the daughter had seen on the state's website. This is an entry-level position requiring the balancing of a large caseload, for which an agent is tasked with enforcing child support obligations of the parents of minor children. That agent will engage in telephone calls with both the custodial and the non-custodial parent, will document returns of service or subpoenas that have been issued. They will make notes to files, respond to internal inquiries from members of the legal department and or the senior casework supervisors about the status of particular cases, and on a rotating basis will be tasked with answering the phone and greeting members of the public who show up to the office. The state's Human Resources Department originally selected 7 candidates who were already union members and for whom priority was to be given for this particular position. Petitioner's daughter was not among those candidates. The 3 senior casework supervisors to whom all agents report rejected all 7 as lacking the required education to perform the job. The state's Human Resources Department then forwarded the applications of the remainder of the candidates, from which the senior casework supervisors selected 6 people to interview. The petitioner's daughter was the only one who did not either withdraw from consideration or fail to show for an interview. She was then interviewed by 2 of the 3 senior casework managers. According to the synopsis prepared by the child support employee, which was submitted to the associate director of that agency and included as page 3 of the petitioner's request letter, the petitioner's daughter did quite well at her interview. The petitioner states that the decision to submit her daughter's name to Human Resources for approval to be hired was made by the 2 senior casework supervisors who interviewed her. They later received approval to make an offer, and they recently did, which was accepted. At no time did Attorney Glucksman, was she consulted or even notified by her colleagues that her daughter was being interviewed, nor did she have any input in that process. As a new agent, the petitioner's daughter will be required to join the union, and her salary will be determined by the union's collective bargaining agreement with the state, which the petitioner has no role in negotiating. Petitioner further states that other than perhaps running into her daughter in the building in which they will both work on separate floors, or the petitioner's delivery of an occasional training to employees or potentially consulting on a difficult case, interactions with her daughter will not likely occur. The petitioner offers that in the event a disciplinary matter involving her daughter were to require intervention beyond the 3 casework supervisors and or 2 assistant administrators who work under the petitioner and who would ordinarily, in the course of their regular role, conduct those official duties. The petitioner would recuse from participating in all related discussions and decision-making, and the associate director, petitioner's immediate supervisor, would act in her place. Petitioner adds that if she were called upon to approve an accommodation request by her daughter for medical or some other leave, she would recuse, and the matter would be addressed by the associate director without her involvement. The petitioner states that both the associate director and his direct superior are aware of and agree to this proposed alternate chain of command. As a public employee subject to the Code of Ethics, the petitioner may not take official action that will directly financially impact her daughter, and the Code of Ethics also contains very specific provisions aimed at curbing nepotism, which are laid out in Regulation 1.3.1. Specifically, a public employee may not participate in the supervision, evaluation, appointment, classification, promotion, transfer, or discipline of any person within their family or from delegating such tasks to one of their subordinates. The Ethics Commission has issued numerous advisory opinions applying these provisions to analogous questions involving family members. Several such opinions are cited on page 4 of the draft. Commission takes the position that a public employee serving in a supervisory capacity will satisfy the code's conflict of interest and nepotism provisions by recusing from matters directly affecting their family member. Here, the petitioner was not involved in creating the advertisement for the position to which her daughter applied, nor did she participate in the selection or interviewing of candidates or the decision to seek approval from the state to offer employment to her daughter. Also, as the administrator, the petitioner is already insulated from the supervision of her daughter by 2 assistant administrators and 3 senior casework supervisors. Because her daughter will become a union member, her salary, of course, will be determined by the collective bargaining agreement, which the petitioner will have no role in negotiating. Disciplinary matter were to arise, petitioner, or if she were called upon to request a leave, to consider a leave request, she'll recuse, her supervisor will handle it. In consideration of the petitioner's representations and the applicable provisions of the Code of Ethics, and consistent with past advisory opinions issued, it is the opinion of staff that the proposed alternate supervisory chain of command described by the petitioner is reasonable and sufficient to insulate her from apparent conflicts of interest regarding matters involving her daughter's employment. That having been said, Attorney Glucksman is advised to remain vigilant in identifying and avoiding any conflicts that might arise given the position of her authority with respect to her daughter that are not addressed in this particular draft or have been contemplated at this time. She is encouraged to return to seek further guidance as warranted. I'm happy to answer your questions or to defer to our petitioner as appropriate.
Thank you. Ms. Luxman, you've heard the presentation from Ms. Revicious, previously seen the draft advisory opinion. Do you have any questions, concerns, or comments?
No.
Members of the commission, any commissioner have any questions, concerns, or comments?
I do. You mentioned, the union, I believe, determines the amount of salary, and the union determines who receives what insofar as any promotions and so on and so forth. Is that an accurate statement? Either one of them.
I defer to you.
So just to be, I was in the legal department at child support from 1999 until just became the administrator in the last month or 2. So I haven't been involved in that. There is a step ladder for agents. Agent 1, then they can, believe it's at like almost akin to like a desk audit after a certain length of time to get to an agent 2 and then an agent 3. So that is done internally at child support. I haven't been a part of any of them yet since I've just been in this new role. for a short period of time. So obviously that would happen to my daughter. She was going to be in 3 years from now making that request. That would be, so I don't think that's done by the union. I think that's within internal in terms of when agents get to the step ladder in terms of increasing in responsibility and income. But that is, then those salaries are determined by the union. But again, I haven't been a part of that process yet. That answers your question.
Who funds this?
The Child Support Agency, so it's part of the Title D of the Social Security Act in terms of funding for child support. So our funds are federal, and the state to fund the child support program, which is assists parents that are non-public assistance, and then to reimburse the state for part of the public assistance block grant for those cases that do under the Title A of the public.
She had nothing to do with, salaries, nothing to do with, submitting a budget, nothing. Who's the administrator?
Well, I believe that the budget, I'm part of that with the associate director for the child support agency. But in terms of the classification of agents or anything like that, no.
You have the administrator, you are the chief.
No, there's one above the other.
Oh,
Right to
and
be.
that person's more involved with the budgetary aspects of the,
Yes, I haven't gone through the budget cycle yet in the new role.
Any other questions or concerns for commission members? Hearing none, is there a motion to approve and issue the advisory opinions presented by the staff?
so move.
Motion by Commissioner Ritchie, seconded by Commissioner Browner. Roll call vote. Commissioner Susie?
Aye.
Commissioner Browner?
Aye.
Commissioner Callahan?
Aye.
Commissioner Cederini?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Ritchie?
Aye.
The chair votes aye. Thank you very much.
Thank you
Appreciate
for your
it.
time. Nice to see you.
Last item on the advisory opinions is Dylan Chase.
This draft can be found at tab C, and our petitioner, who is a Block Island resident, is joining us remotely.
Back that boy, this is more, that's, I've been stuck there. Me too.
Mr. Chase, can you hear us? Okay.
I can, thank you.
Good morning, Mr. Chase.
Good morning.
Good morning, Mr. Chase. Nice to see you.
Good morning, Lynn. You as well.
Petitioner is the superintendent of New Shoreham's sewer plant. His duties are outlined at the bottom of page 1 of the draft. Mr. Chase supervises the work of 3 sewer operators and 1 administrative assistant. His regular work hours are from 7 a.m. to 3 p.m. Monday through Friday. There are 1,200 septic users on Block Island who reside outside of the town's sewer district. They are not connected to the town's sewer system. Neither the petitioner nor the sewer commission that hired him has any oversight over people who are not connected to the sewer system. There are roughly 400 sewer customers who do reside within the town's sewer district. Those customers have wet wells or sewage tanks on their property, which discharge periodically into the public sewer system. Final treatment of the sewage for these customers occurs at the town's wastewater treatment facility. The petitioner states that wet wells and sewer tanks should undergo the same adequate maintenance that septic systems used outside of the sewer district do. There's a town ordinance addressing one product in particular, which mandates that a 2-year operation and maintenance service contract for the unit must be obtained and submitted to the sewer superintendent, that is the petitioner, before a permit for installation of the sewer connection can even be obtained. Last August, Mr. Chase established Block Island Septic Services. This is a private company through which he answers call from people who require service and maintenance for their septic systems. He operates this company out of his home outside of his municipal work hours. He has no employees he does not advertise. To date, he has serviced only 2 clients, both of whom reside outside of the sewer district. The petitioner seeks this advisory opinion to determine whether he may provide maintenance and other services in his private capacity to customers within the sewer district. Mr. Chase explains that although none of the work he performs for people outside of the sewer district would ever intersect with his public role, the same cannot be said for people within the sewer district. As the sewer superintendent, the petitioner must inspect the sewer connections of those customers. Should he discover a broken or defective component associated with the installation of a sewer connection, he has the authority and the responsibility to notify the customer in writing of the need to correct that situation. The petitioner acknowledges that were he to service the wet wells or sewage tanks of customers within the sewer district, a conflict of interest could occur in the event that he is called as a witness before the sewer commission by which he is employed to answer questions about the circumstances surrounding the need for a particular service, the nature of the service he provided, and other relevant information. Mr. Chase states that general maintenance to wet wells and sewage tanks on an annual basis would reduce by 50% or more the 3 to 4 costly emergencies that arise in New Shoreham between Memorial Day and Columbus Day each year. He explains that one technician who previously serviced customers within the town's sewer district has since moved off island and is no longer generally available to travel to the island. The petitioner adds that technicians from the mainland are either unable or unwilling to spend the time and money to travel to New Shoreham to perform maintenance work. There are 2 septic tank installers and 1 local plumbing service on Block Island that perform emergency repairs in town, but they either do not meet the requirements to perform annual maintenance or they're unwilling to do so because they're just too busy with other projects. Mr. Chase states that even though approximately 38 customers within the sewer district have mandatory service contracts with the contractors who installed their systems, those contractors are not honoring their maintenance obligations. The petitioner underscores that his request to be allowed to service customers within the sewer district in his private capacity is based solely on the general unavailability of qualified technicians to meet the demands of those customers. Petitioner states that he was once sent to respond to an emergency within the sewer district in his public capacity, but that he does not do so regularly. The applicable provisions of the Code of Ethics are laid out on page 4 of the draft. They include the following 4 prohibitions. First, not accepting other employment that will impair his independence of judgment with regard to his public duties or require or induce him to disclose confidential government information. 2, not taking official action that will directly financially impact himself, a member of his family, a business associate, or a private employer. 3, not representing himself or another person, or acting as an expert witness before the public agency by which he is employed. And 4, not participating in a matter in which a business associate or another person authorized by a business associate to act on their behalf appears or presents evidence before the public agency by which he is employed. The Ethics Commission has consistently opined that public officials and employees are not inherently prohibited by the Code of Ethics from holding other employment that is secondary to their primary public positions. But that other employment may not create an interest in substantial conflict with their public duties. And the Ethics Commission looks at several factors when trying to determine whether that is the case. They include, but are not limited to, the following: the nexus between the official's public duties and the other employment in which they wish to engage, whether the employee completes such other work outside of his normal work hours without the use of public resources, whether the employee is required to appear before his own agency as part of that secondary private employment, whether such other work is to be conducted outside of areas over which the public employee has decision-making jurisdiction, and whether the employee uses his public position to solicit business or customers. A number of previously issued advisory opinions supporting the code provisions And the factors just mentioned are on page 5 and 6 of the draft. Here, despite the likelihood that Mr. Chase could serve his customers within the sewer district on his own time without the use of public resources, the remaining factors employed when considering potential conflicts regarding other employment present insurmountable issues here. The nexus between petitioner's public and proposed private duties is such that confusion would likely occur during the inevitable overlap of the two positions. For example, when the petitioner is called in his public capacity to the home of a customer within the sewer district to identify a problem with a wet well or a sewage tank, the petitioner would then be the one to return in his private capacity to rectify that problem. The petitioner acknowledges that were he to identify the installation of a sewer connection as the source of a particular problem, the installer could allege that the fault was not with the installation, but with the subsequent service to that system. If the petitioner performed that service, he would then be required to inspect his own work, which is prohibited by the Code of Ethics. Furthermore, the work in which the petitioner seeks to engage in his private capacity is directly within an area over which he has decision-making jurisdiction in his public capacity. Also, use of his public position to solicit business or customers for his private company could become an unavoidable, albeit unintentional, consequence for this petitioner. Staff is aware of the unique needs of the town of New Shoreham, given its remote location, its low population. There is, however, no hardship exception for secondary employment. Hardship exceptions are limited to the prohibition against representing oneself before the public agency of which he is a member or by which he is employed. If this were instead, for an example, a situation where Mr. Chase sought to leave his municipal position in order to start a private business to address the need for septic and related services on Block Island, an exception to the revolving door requirement that he ordinarily not appear before the sewer commission for 1 year before the expiration of the date from which he left, a hardship exception might be allowed. Staff recognizes that allowing Mr. Chase to provide services in his private capacity to customers within the sewer district could be of great convenience for those customers. However, the circumstances as described here don't appear to be temporary, and the petitioner's private clients would become his business associates, which would expose the petitioner to even more potential conflicts of interest. Service providers are available for true emergencies, and a number of customers within the sewer district and or the contractors who install their sewer connections are required by municipal law to produce evidence of an executed service contract to the town, to the petitioner, in advance of a sewer connection installation. Also, the petitioner has on at least one occasion been sent to address a sewer emergency in his public capacity. For these and all of the foregoing reasons, and consistent with the applicable provisions of the code and prior advisory opinions issued, it is the opinion of staff that the petitioner is prohibited by the Code of Ethics from providing the services in his private capacity to customers within the town's sewer district. I'm happy to answer your questions on the board, Mr. Chase.
Thank you, Mr. Decious. Mr. Chase, you were able to hear Mr. Decious' presentation,
I was, thank you.
previously seen the draft advisory opinion.
Yes, I have read it.
Comments, questions, or concerns about the advisory opinion as drafted?
My only comment, I want to state that I sincerely appreciate Lynn Radicche's time, consideration. I appreciate your time and consideration on this opinion. It's a very difficult situation. Although I completely agree with the letter of the Code of Ethics in this circumstance and completely concur with her opinion, or her draft opinion to present it before you. Coincidentally, yesterday I had to respond to a sewer line failure for these low pressure systems. Roughly 1,000 gallons spilled out into close to damaging a wetland, or putting a wetland in peril. Again, this circumstance could have been avoided with proper maintenance. So, as stated, although I agree with the practical application, and language of the Code of Ethics, on a practical standpoint, as far as, getting the work done and, protecting the ecosystem and public health. I remain to have some concerns. So although, I guess my request would be if there was any stipulation or conditional or, consideration for, allowance until we have, a better service provider beyond myself, could an allowance be made? Within the confines of the Code of Ethics as it's written, I don't see the gray area there. However, on a practical standpoint and for the good of my community, I definitely have some concerns. I appreciate your time.
Thank you very much. Mr. Fuchs, do you have any comment to the idea of a temporary sort of emergency allowance?
I do. If I may first, thank Mr. Chase, for being here today and for his cooperation during this process, which this one took a little longer. He is one of the most sincere petitioners with whom I've ever dealt. He's been patient teaching me about how all this works. And his is 100% sincere. And this is a gentleman who wants to do the right thing. I think it could become a case of nice guys finish last. Actually, the system that Mr. Chase just explained that had the problem yesterday when he said the low pressure, I believe that's one of the 38 that
It is.
requires the system. So why the heck people aren't demanding that, the contractual responsibilities of the other party with whom he contracts is beyond me. But I also am concerned that if Mr. Chase goes out to a private property within the sewer district, and we're all human, and I'm sure he's the best at what he does, and something goes wrong, if you don't think that person's gonna sue him privately and sue the town because he's the superintendent, it's gonna happen. And I just don't wanna see this. Also, if he's allowed to do this, who's gonna look for somebody else to come do it? We got Dylan. The Ethics Commission said he can do this. And in a true emergency, I believe it was Thanksgiving Day, not long ago, Dylan was sent out to a piece of property within the community. The town understandably doesn't want the liability of servicing these private customers. But if they send Dylan Chase out to do it, or if he's allowed to do it, I don't think they'll necessarily escape that. If this was a case of Block Island has found someone, there's a gentleman moving his family from the Midwest, they want to be Islanders, they'll be here September 1st. Can Dylan hang in the meantime? I might be able to say, emergency's an emergency. But I can't, in good faith, out of protection of this petitioner, to be honest, in this case, recommend that he be allowed to do this.
Mr. Chairman, I see it somewhat differently. Because of the nature of the service that may be required on a septic system, sewer line, or whatever, a failure could have significant health issues to adjoining property, wetlands, or whatever. I noticed that within the documents that came forward, that the town council, apparently in consideration of this situation, said we would grant the petitioner the authority to proceed and waive any particular conflict as long as the Ethics Commission would so approve. They weren't trying to supersede our jurisdiction. However, taking into account significant concerns about health issues, need, freshwater wetland, water supply. I defer to the commissioner as to, well water issues. If contamination happens for a period of time. It seems that there may well be a problem with our regulatory process when you consider that Block Island is where it is. And people don't normally, the other providers aren't getting there. But it seems that we should have some concern at the public health issues.
If I may briefly respond? Sure. I agree completely, and this was one of our conversations that we had. I do note that it was, I believe, the sewer commission that took that vote to say, we're good with it, if the ethics commission is good with it.
Sure.
And when Mr. Chase, please correct me if I'm wrong, the substance of this, as I understand it, is there are people to respond to true emergencies, and Mr. Chase, in his wisdom, has noted that proper annual maintenance may prevent some emergencies. And that, I believe, is the bulk of what he's looking to do. I'm sure that he could service an emergency as well. But generally speaking, it's my understanding that emergencies can be dealt with and are dealt with. And this is more of a, let's beef up the general maintenance to avoid such things. Wet wipes get caught in the sewer, let's call Mr. Chase and have him take them out. That sort of thing.
Who does that? You have someone that, Mr. Chase, there's someone, that you're aware of that fills in such a
There,
situation?
we have an emergency response. For instance, again, coincidentally, yesterday I dealt with a system which had 4 other low pressure system users. A blowout cap, which is essentially a clean out on the low pressure system because it's pressurized, failed. Consequently, of roughly 1,000 gallons or more spread down the road, moved towards a wetland. In my sewer capacity, as superintendent, I was notified. I responded with a vacuum truck. I cleaned the ground. And then Oceanside Plumbing also responded, and were able to fix the blowout cap or the clean out with a riser coupling. So there is a response. However, it wasn't sufficient to protect the wetland. It's reactive, not responsive. That's my concern.
So when it comes to a response, it still depends on you.
It still depends on me, correct? So
And,
in whatever capacity that is, I can be in my role as superintendent. It is a reactive consequence of a failure that I respond to a situation privately. Whereas in a private business capacity, it would be more proactive. I would be more responsive in compliance to the maintenance agreements. But again, I understand the conflict of this. It's a difficult decision. Either can I ensure that going forward, there will be no adverse health effects or consequences to wetlands? No. And
how long have you,
go ahead.
sorry,
No,
how long have you superintendent?
since 2019, so roughly 6 years.
But he's worked there twice as long.
Yeah,
But
that's-
I've worked at the sewer plant since 2012.
Yeah. As, Councilor Lucius correctly stated, sometimes nice guys do finish last in the situations, and it's sad.
And no, I understand the world we live in, the difficulties in navigating that. So I appreciate.
You have a decision to make, if the commission, adopts the opinion of, the prosecutor, you have a decision to make. Either you're a superintendent or you're the person who responds to situations.
Sure. In,
Right.
in a capacity of, my public role comes first. It's for the greater good of the community. I have no, ambitions or aspirations to leave the town, employment. My request to you is simply for the common good. It's a practical response. I see a void in service. I see some derelict systems. I have no authority over those systems beyond essentially working with the private homeowner to recommend services. However, although I have recommended services to these private homeowners, very few the service providers that were initially responsible for these systems are no longer responding, to put it.
Sad situation, there it is.
It's a difficult situation, correct?
Commissioner Callahan?
So, and, from a perspective of, Attorney Reedy share with us, is there a analogous, a Good Samaritan type of approach that could be applied for Dylan in this case, Mr. Chase? And again, as a layperson, it's more in line with, could the town potentially contract for periodic oversight so that as he's doing his work, there is a second set of eyes that have a potentially, they're not conflicted. Or is there, and this may be well outside our lane, is there is part of our advice that there's some potentially support from DEM in terms of this particular issue to provide him oversight, understanding the uniqueness of this particular, the island, the distance, the lack of qualified personnel, so that there's an oversight capacity for him to insulate him as you suggested.
Sure, I very much appreciate your question, and I will tell you in all honesty and earnestly that I sat down to write this so that he could do it. From the start, this is Block Island, it's Mr. Chase, we've got to do the right thing. I couldn't do it. And we talked on the phone and I said, how about they make this part of your public position? Give you a little more money. Well, there, and naturally there's a problem. They don't want they don't go beyond the street, I believe is what it is. Well, what about an RFP? I read that Block Island was looking for a physician not long ago, offering quite the nice package to get someone to live there. And I don't know that was a particular option, but why RFPs aren't flying out trying to get somebody? There is a list. Dylan attended a very good program that I have the privilege to present to annually. It's a wastewater boot camp in DEM office where everybody's learning to do what Dylan does for all the cities and towns. All Westerly, have somebody from Westerly come down, or Charlestown, or like tax assessors do when they have to assess their own property, they trade. There is an answer here. And I really don't think it's up to Dylan Chase to solve the problem for this island. I think it's the island's problem to solve. And I just, again, I couldn't write it. I tried so hard to write it that way.
Commissioner Rapido, I'm curious whether you have thoughts.
Yeah, I've been quiet. Dylan and Scott Rabideau,
Scott.
and, I've done a lot of work on Block Island, for wetland permitting, both coastal and freshwater wetland permitting. He can still deal with the 1,200
Absolutely.
on-site wastewater treatment systems that are denitrification systems that are outside of the district. That's important, obviously, because similarly, people are supposed to have a maintenance contract and it's a requirement that's put on the deed when they get that permit. I don't know how it works inside the district. For these 400 customers. But yeah, the only thing I could think of would be to have the sewer commission, set up a program where, hey, if you wanna have us come out and do regular maintenance, here it is, and then it wouldn't be a conflict for them, because even if they gave them a stipend, right? Even if it was just on a per unit basis, here's your stipend, but it would have to be set up through the sewer commission. Cause I agree, the nexus, for the conflict is there. But there's, when you talk about having people come out to do it, there's not enough money, honestly. To go out and set up practice on Block Island to deal with, there's 400, but maybe you only get, 50 or 60 customers, and to travel back and forth. It's, as a private consultant for a number of years, it's sometimes not profitable, and that's why they don't do it. That's why they don't service the island. It's very difficult.
We talked about, what if they go over for 2 days a month, and they get everybody, or twice a month.
Yeah, glaring, it's a good point, and the glaring comment that, Prosecutor Beaches. Other books.
Yeah, I mean, the commission doesn't seem to see this as a problem, Dylan, right? Or is this just your
The
personal?
commission does, the commission is not aware of everyone has, I guess, the best interest of the common good, and we understand the Block Island factor. So they are willing for the common good to waive liability. That's the extent of the conversation.
So who waives liability, the individual or the town?
The
That's
sewer
the point
commission, the sewer commission, the town, the sewer.
See, that's
commission.
the concern I have as well.
If the town is waiving liability to allow Dylan Chase to go out and service these items, why aren't they making this part of Dylan Chase's job to do it? And I also want to say that, as I do for any petitioner for whom I've written an advisory opinion that is not in their favor, this was no surprise. I just want everyone to know that. I read it once.
To just answer that for clarification, the appetite for any employee of the sewer commission to answer for derelict systems is a conflict in and of itself. We have to run and operate a wastewater treatment facility. The wastewater treatment facility takes, we have, as stated in the draft for you, there's 3 other operators beyond myself, and then an administrative assistant. It takes all day, and especially considering right now, all day long, we have a list. We're checking off the list. We're raking bar racks. We're checking systems. We're checking pump stations. Our first and primary responsibility is to the wastewater treatment plant for the New Shoreham Sewer District. Yesterday, as I said, of consequence, I was removed from my duties at the wastewater treatment plant to respond to an emergency within the sewer district, but to ensure adequate repair, which in doing so, left 2 other sewer employees to handle all the lab functions, duties, tasks, and responsibilities, and all the operations for the day. The burden would be too great. There is some semblance when I am in control, I say control lightly, but when I have oversight over my system, I understand my system. I know I check everything. We have checks every single day. We know the nuances of it. We have a reasonable expectation of our duties and responsibilities each and every day. What happened on Thanksgiving 2 years ago, what happened yesterday, and what's happened in other circumstances remove us from our primary responsibilities and our taxing. The town doesn't have the budget to support increasing staff to the capacity that it would ensure that these systems remain in compliance. It's not something that's practical, for, I suppose, for, again, in the same circumstance of why individuals won't come over to Block Island to service 38 systems. It's not practical to pay someone an annual salary to service these systems either, so. And again, for me, this is not about, wouldn't be a financial windfall by any means. This is simply, I see that there's a lack of service. I want to fill the gap. I'm capable. It's, but I had to get this opinion. And either way, whichever way it goes, I completely, I completely support your opinion, so.
Asking. If the commission, again, agrees with the opinion of Prosecutor Ignatius, what would, in your opinion, what would the town do? Because right now, the town council was hoping that, we would, reject her, not agree with her opinion. But in the event we do, in your opinion, what will the town council do? What would the town government do? Knowing that you can no longer serve both roles.
If the answer is, that I would not be able to serve in my public capacity, I would defer to the emergency response. Again, my public capacity, my public role, it's my primary position, it's my primary employment. I have no aspirations to move outside of that, so maybe I didn't.
What would the town do? And right now, they're comfortable having you in both positions. They're
Correct.
hoping that we allow that to continue. But in the event we don't allow that to continue, so to speak.
Right.
What will they do?
That, I essentially, the response will be reactive until someone fills the role. We will respond to emergencies as we have done in the past. I mean, I've taken, even within the town role, by legislation, the sewer commission is separate from the town of New Shoreham. With certain oversight and exceptions, without getting too far into that. For instance, though, I do not, it is not my responsibility to service like town porta-johns. It's not my responsibility to service the facilities at the town beach, which are technically not on the sewer district. But in the best interest of the town, whereas the service providers, again, left the town in a place of need, whereas a whole facility would completely shut down. I have to fill that role because I'm capable. I have the means to do so. Again, I'm taken out of my primary responsibility in order to fill those roles. I will continue to do that as necessary. I suppose either way, the town will rely on me to service or to support service for these systems.
Yes, Commissioner Senator.
If you or the legal counsel could provide guidance, a process to amend the opinion or the recommendation of staff, which I understand completely the parameters of restraint staff is facing. If there were to be an amendment to the opinion or accept except if the appropriate municipal authority, because of a determined emergency, allowed the petitioner to undertake the requested activity. Is such an amendment, taking also into account the Commissioner Callahan's concept of Good Samaritan, can we consider that?
Yes, we have approved
opinions with amendments in the past. We could certainly do that. In this case, since we're contemplating really kind of a complicated issue, it might be best to continue this to the next meeting. And perhaps Ms. Radishis could propose some amended or revised language for your consideration. And it could be discussed at the next meeting, rather than just kind of doing it on the fly. Because it appears that Ms. Radishis has done everything possible to try to make this work, but she's really confined by the code of ethics, which is really the extent of our jurisdiction. So, you know, it may be that maybe in consultation with Mr. Chase, you can come up with some revised language that may address the concerns that have been expressed by the commissioners today, and that could be considered at the next meeting.
Of course, I'll be happy to do that. I just want to make sure that I understand that the emergency as deemed by the town of New Shoreham that would require Mr. Chase to go out. Is this an emergency that the town would deem would be its own emergency if something were going wrong within the sewer district? Because if so, my question is why the town wouldn't send Mr. Chase out in his public capacity to address an emergency.
I think one of the other points, which was a very good point raised by Commissioner Rabideau, was that I think what Mr. Chase is saying is that it's the lack of execution with respect to the maintenance agreements, the preventive maintenance, that not being done, which eventually ends up in an emergency that he then has to respond to. And I thought Commissioner Rabideau's suggestion that rather than Mr. Chase doing that preventative maintenance through his private LLC, that if perhaps that preventative maintenance could be done by the town. Correct?
Correct, yeah, the town.
Town, billed to the town, and then Mr. Chase, obviously, his compensation would be adjusted to reflect whatever work he did on that, or someone else from the sewer.
That's right. If the sewer commission were to set up a situation where, hey, for $200, we'll come out and maintain your system. And they could defer it to Mr. Chase, or they could defer it to their engineering consultant, Jim Jeremia. And anybody like that. That seems like the most logical way for the town to address the situation and not cause this conflict.
That would remove any
Correct.
violation of the code of ethics.
Correct.
And that was the original suggestion, with the exception of that $200 fee, which may change the game. But it was my understanding that the town doesn't want to go beyond the street because they don't want responsibility for it.
Right, but if they established a program where for a fee, we can go beyond the street, but it's.
Perhaps increase their own insurance or something.
And,
Let's hear from.
if I may, there is a similar program for grease traps. There's an inspection of grease traps that I conduct, or representatives of the sewer district.
Commercial?
On the commercial district, we inspect grease traps weekly. We don't, obviously, it's by town ordinance that we're and preventing grease discharge into the sewer system. But there is a program in place. In a similar capacity, it may be advisable to amend to the opinion to make an allowance for inspections and service recommendations outside of on private systems. Perhaps or to develop a program for annual maintenance or even annual inspections. But to remain in line with it falling under the public umbrella. I think I agree with that. I think that's the better way forward. I don't see any way outside of that, with the exception of, Jim Jeremia was brought up. If I was to do some work, I could, in theory, call Jim to send an inspector out to inspect my work. So if we were to incorporate maintenance on those systems, I could have a mediating inspection for those circumstances. I think that may be included in the opinion as well.
This is what I had.
Insider baseball. Jim
This is what I had in
Jeremy is
when
the
I
town
asked you that.
engineer. Well, Jim Jeremy is the town engineer, and he's been the town engineer years. It's a private consulting firm. He's not an employee of the town, so he has employees on staff for the systems.
This is the point I was making to you, Mr. Chase, when I asked you, what would the town do in the event we approved this, opinion? It's exactly what Commissioner Rabideau pointed out, the process they would have to do. So I think that would happen. I think if we continue this matter, I think that Mr. Dees is not gonna get around the issue of legality and so on and so forth. We continue the matter, we're just wasting time. Let the town do what they have to do, as you pointed out. That's my opinion on that basis.
And also, in that context, Mr. Chase, do you think that receiving this opinion will help you in addressing the issue with the town council or the town?
I do. I think the clarification is important for the future, for anyone who comes after me. I think this opinion's very valuable. Thank you.
Historically, municipalities, for example, when they've run into issues about trash on private property, I mean, the municipalities have the authority to go forward, clean it up and build. Same thing about painting a house. You don't paint your house, it doesn't meet the building code. Municipalities do have authority to undertake remedial action and put a lien on the property.
You can see trash. These systems are underground.
I know.
You know, it's out of sight, out of mind for most homeowners, especially when you've got a homeowner who's not a Block Islander.
Right.
They're coming in only in the summertime. They don't know if those systems have been, fully vetted prior to their renting it or their families moving in. So I think, what we've talked about is probably the best option for the town. And I agree with Commissioner Ritchie. We should just, vote this
As is.
as is. I don't
As
think
a
there's anything we
forcing
can
function.
do
Forcing function.
to take away this nexus of a conflict between the superintendent and a private company servicing within his district, within his.
This particular advisory opinion, if voted on to approve it, could be instrumental to the town in perhaps fashioning a follow-up request for advisory,
Correct.
if necessary.
Correct.
Our jurisdiction.
Right.
Right. So, Mr. Chase, I assume if there's one thing that's come clear to you in this process is we would love to be able to help you here, but we can't.
I
So-
completely understand that.
I think we are.
Well, we're helping.
I think this is.
You are.
Yeah.
You are helping. The decision is helpful. The clarification is valuable. Again, for posterity, it's extremely valuable. So it provides clarification to the town of New Shoreham and to the Sewer Commission, and for anyone interested in taking a public role. I think this is very important. I appreciate your time.
I would also note for Mr. Chase that this video will be available on our website. If anyone from the council or the sewer commission would like to see the discussion and debate, it might be helpful.
I was gonna say exactly the same thing, that you might want to alert them to the existence of this tape.
I will.
All right, everybody had a chance to ask a comment, say, stuff in. Is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
A motion by Commissioner Rabideau, seconded by Commissioner Susie, I believe. Roll call vote, Commissioner Susie.
Aye.
Mr. Browner. Aye. Mr. Callahan.
Aye.
Mr. Centarini. Aye. Mr. Rabideau.
Aye.
Commissioner Ritchie. Aye. The chair votes aye. Thank you very much on this one, Mr. Chase. We appreciate your attitude and style.
Thank you. I appreciate your time. And Lynn, thank you as well.
My pleasure. I have a husband who's recently retired who loves Block Island.
May I? Or was it?
Yes.
Yes, sir.
That was one of the nicest.
The next item on the agenda is a motion to go into executive session to wit. A motion to approve the minutes of the executive session held on June 10th, 2025 pursuant to RI Gen Law section 42-46-5, A 2 and 4. In B, in Ray Robert L. Lombardo, complaint number 2025-3 pursuant to RI Gen Law section 42-46-5, A 2 and 4. And then a motion to return to open session. Is there such a motion?
So moved.
Motion by Commissioner Callahan, second.
Second.
Second by Commissioner Senarini. Roll call vote, Commissioner Susie.
Aye.
Commissioner Browner. Aye. Commissioner Callahan.
Aye.
Commissioner Senarini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. Aye. And the chair votes aye.
So just note that the live stream will close while we go into executive session, and then it will come back up after you come back into open session, though there is no one in the audience to hear this right now, so. Good to.
But it's there.